You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 86, International Trademark Registration, the Madrid System. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. In the last episode, I talked about how to get your design registered throughout the world using the Hague system. Now, that just creates a simpler process than filing separate design applications throughout the world. And I also talked about how it's similar to using a PCT application to get patent protection throughout the world. Now, there's still no single worldwide patent or worldwide design registration, but at least if you use these certain systems, it cuts out a lot of the steps and can save a lot of money compared to if you try to start from scratch and file separate applications in each country. This episode is going to be about getting worldwide trademark registration. Now, just like for design and patents, there's no such thing as a single trademark that gets you protection in every country. You still have to apply in separate countries, but if you use something called the Madrid System, which is actually two different treaties called the Madrid Agreement and Madrid Protocol, together they're called the Madrid System, you can cut out a lot of the steps to get your trademark registered in numerous countries throughout the world. I believe currently there are 121 countries that are part of the Madrid System, so you can't get your trademark registered in every country, but most of the ones you're probably interested are part of it, but you do want to check the list. Now, why would you want international trademark registration? The most common reason is that if you're a company and you start having business or selling products throughout the world, you don't want counterfeiters to come in and start making products with your mark. If you don't have your mark registered in those countries, it can be difficult or sometimes impossible to stop them from putting your mark on the counterfeit products unless you have a registered trademark. Basically, what happens is that you file your first trademark application in the United States, just like any regular U.S. trademark application. This is a little different than a PCT, a patent application, where you can file an international application in an international office to start with. You're not required to first file a U.S. patent application before filing a PCT application. But for trademarks, you have to first file your trademark in a specific country. So in the U.S., if you're a U.S. person listening to this podcast, it's going to be in the U.S. So why is using the Madrid system advantageous? What steps does it cut out? There are a few advantages. First, it creates one central registration and one place to pay your payment fee. If you did 100 separate countries, you'd have to make 100 different payments. And with the Madrid system, it's just one central payment. You can also renew your trademark in one place at renewal time. And that makes it cost a lot less at renewal because you don't have to pay 100 different attorneys to process everything. You can just do it once in one place. It's also easy to do name changes and ownership changes because you can do it in one place. If you changed office locations and you need to change an address for your trademark registration, imagine the cost of paying 100 attorneys just to do an address change in 100 countries. Instead, you just have one central location. Now, it's not all sparkles and roses with the Madrid Protocol. There are some disadvantages. If your mark gets refused, then you do have to hire a local counsel in that country to take care of it. And maybe it would have been cheaper if you had someone in that country do the initial filing to make sure everything was fine according to that country's rules to begin with. Also, in the first 5 years of your mark being registered, your mark can be called it's called an attack, which means that if your home mark, your first filed application, is canceled for some reason, then your international registration is also canceled. Also, you can't amend your mark. In some countries, if there are issues, you can amend your mark to fix it, like add or remove a period or the word the, small little things. But if you're doing the Madrid Protocol, it can't be amended. You can't also expand the goods and services that are associated with your mark. And in some countries, you can do that if you file individually. In order to file an international registration in the United States, what you do is you use the United States Patent and Trademark Office as your office of origin. So what do you actually do? Well, first you have to make sure that you're allowed to file. You either have to be a national of the United States, domiciled in the United States, or have a real and effective industrial or commercial establishment in the United States. So some type of office of some sort. I talked about filing a U.S. trademark before, and you go through the same electronic system called the TEAS system, T-E-A-S. You can do it on paper form, but I wouldn't recommend it. As I mentioned, the international application has to be based on a U.S. application for registration. It doesn't have to be registered yet. It can just be in the application. The goods and services, and that's the types of things that you say your mark is going to be used on, such as shirts, clothing, electronics, those types of things. It has to be the same when you file your international application or narrower. You can't start adding things that your mark is going to be on compared to your original home application. And after that, there are a bunch of boxes to check for all the countries that you want or region. Most places, there's one box for one country. There is a box for the European Union, which covers many countries and counts as just one selection. So that makes it pretty easy if you want protection throughout almost all of Europe. And how much is this going to cost you? WIPO has a fee calculator. I've mentioned WIPO before. It stands for the World Intellectual Property Organization. They have a useful website that you can go to. You put in the date that you're going to file. There's a drop-down menu for the country where your home application was filed. And so you would select the United States. Then you select the number of classes. I've talked about classes in the US trademark episode, but let's just be simple and pick one class. And then you select new application. And you're going to get a list of the 120 or so countries with boxes to check. I'm just going to keep this pretty simple, and I check the boxes for Japan, China, and the European Union. Then I click continue, and the amount is listed in Swiss francs. So be sure to convert it when you want to know how much it's going to be in US dollars. And it tells me that the basic fee, and this is just the fee for the application, is 653 Swiss franc. China is 249. The European Union is 897, and Japan is 108. So that's a total of 1,907 Swiss franc if I want these three different countries and regions. And right now, the Swiss franc and US dollar are almost exactly equal, and 1,907 Swiss franc is 1,940 US dollars. This is how much it's going to cost you to file your international registration application. Now, if you're wondering why it's done in Swiss franc, it's because WIPO is located in Switzerland, so they do everything in Swiss francs. But since you can pay by credit card, doesn't really make much of a difference in the end. After you submit your application, what happens? If you submit it in the US, a US examiner is going to certify that you did it correctly. They're not going to be, looking for similar marks or anything. They just want to make sure the forms are filled out right and everything looks fine. Then it sends it to the International Bureau, and it's going to get reviewed by an International Bureau examiner for irregularities, formality type things. They're not doing any substantive examination. If there are any issues, you'll get notified, and hopefully you can fix whatever they say the problem is. And you can usually do that through the United States Patent and Trademark Office. After all the formalities are taken care of, all the countries that you selected, they're going to get notified that you filed an international registration application. And those countries have 18 months to refuse your application, or else it's automatically protected. And what happens if it's refused? And maybe it's refused because there's already the exact same mark or similar mark in that country, and that country will send a refusal to the International Bureau, and then the International Bureau is going to notify you. And if you get a refusal, you'll likely need to hire an attorney in that country to respond to the refusal. Some other things to note is that, let's say you picked a few countries for the international registration, and then you realize that you want protection in additional countries. You're allowed to do that with something called a subsequent designation, and you're just going to pay some extra fees for picking those new countries. Also note that your registration lasts for 10 years, and it can be renewed if you're still using it. Another thing to note is that if you're just interested in a couple of countries, it may be worth it and less of a hassle to just file directly in those countries by using an experienced attorney in that country that knows the particular rules, so you won't get a refusal to start with. And as always, I'm giving the caveat that I've left out a whole lot of information about international trademark registration, and you'll want to discuss that with your attorney. And there may be specific situations and additional things that you're going to need to do or be careful about if you want international registration. But at least hopefully you know enough information so that if you do want international protection and you're working with an attorney, say, hey, I would like this in several countries. I heard there's something called the Madrid System, and I'd like to go forward in getting protection in a whole lot of countries at the same time. This is something that you want to think about when filing your U.S. application, either at the same time or shortly afterwards if you're interested in getting protection in other countries. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.